The final two cases for Friday, February 3rd, 2023 are as follows. First case, appeal number 125781 in the matter of Robert R. Laing Jr., attorney action and original action and attorney discipline.
Good morning, Madam Chief Justice. May it please the court. Julia Hart, Deputy Disciplinary Administrator, appearing on behalf of the Office of the Disciplinary Administrator, present and ready for argument. And I would request 3 minutes rebuttal.
3 minutes is granted. Thank you, sir.
Robert R. Laing Jr., pro se.
Sorry to Mr. Laing.
Thank you, Your Honors. The case before you today is a summary submission on 2 docketed complaints. What this summary submission is ultimately asking for is that the court impose a 12-month suspension, that this suspension be stayed so long as the respondent complies with the conditions of probation, and that he be placed on probation for a period of 12 months. In looking at Rule 227, which is the rule, our Supreme Court rule, which guides probation in attorney discipline cases, probation is appropriate, particularly in two instances: that misconduct can be corrected by the probation, and that placing the respondent on probation is in the best interests of the legal profession and the public. In this case, Mr. Laing and I come before the court on this summary submission on 2 different docketed complaints. In the first docketed complaint, Mr. Laing and I have agreed to the following facts, rule violations, and the disposition, which was previously discussed. Ultimately, the first complaint arose from a federal lawsuit that was filed in federal district court. An inmate who was held at the correctional facility hired Mr. Laing to represent him in suit against ultimately, among other people, the Federal Bureau of Prisons, the local correctional facility, the sheriff of that jurisdiction, because he suffered a skin disorder that he did not receive adequate medical care for. He hired the respondent, the complainant hired the respondent in August of 2014. In August of 2015, a year after Mr. Laing was hired by the complainant, he filed suit in federal district court. This lawsuit was dismissed by motion in December of 2015. The respondent waited 10 days after the suit was dismissed to file a motion to amend. The court denied this motion due to the respondent's unexcused delay in waiting till 10 days after the dismissal of the case. Then in February of 2016, the respondent refiles the suit in the federal district court. In this instance, the opposing side files a motion for summary judgment. This summary judgment was ultimately granted as the respondent, while he controverted 3 facts, he didn't provide supporting evidence as required by the federal rule of procedure. In looking at the records of the case, the respondent did not send a copy of the lawsuit to the complainants until April of 2017. When this complaint was investigated, the disciplinary investigator requested that the respondent provide him with billing records. The respondent provided most of the records, but not all of the records. The respondent never provided billing records from May of 2015 to November of 2015 as requested. The final issue in this first docketed complaint was the respondent completed his final legal work in this case in October of 2017. From December of 2017 until March of 2020, the respondent sent bills to the complainant in the case, and they were all listed as interest due on outstanding balance, and the interest due during this period was $10,000. Parties agree that the respondent violated rules 1.1, competence, 1.2, scope of representation, 1.3, diligence, 1.4, communication, 8.4G, misconduct. In the second docketed complaint, the respondent was hired by an executor of a will to represent her in her interests in that she hired the respondent in January of 2018. In October of 2018, a motion to have the complainant removed as the executor was filed in local district court. The court removed the complainant as the executor and appointed an attorney to administer the remainder of the will and the probate to the parties. In June of 2020, the attorney administrator that was hired filed a report with the local district court, noting her procedure where the assets were sent out to and some issues that she found in the case. One of those issues that was discovered in this court-appointed administrator's report was that on July 23rd of 2018, the complainant appeared at the respondent's office, asked him to help her find a place to cash a check that was made out to the deceased. They drove around to several banks in attempts to cash this check of $3,268.17. After finding a bank to cash this check, the complainant in this case paid the respondent $700 for outstanding legal services in cash from the proceeds of this check. Beyond just the non-controverted statements from the complainant and the respondent, we know this because the respondent billed for 1.5 hours on this date for trips to the bank with his client, and his billing records indicated that the client paid him $700 on that date. On this complaint, the parties are in agreement that Rule 8.4D was violated as a result of this. Based upon these factors, based upon the aggravating and mitigating factors that exist, the parties are asking ultimately for the suspension that is stayed and probation. The summary submission agreement noted that particular terms of probations would include that the respondent retires from the practice of law by September 30th of 2022, that he work with KLAP to develop and implement a plan for the closure of his practice, that he participate with all ODA required meetings and phone calls, and that he comply with the rules of professional conduct and Supreme Court rules.
Let me ask you about the retirement condition, because that's stated in the plan, and then we got an affidavit from Mr. Laing a few days ago that paragraph 3 of that affidavit says that he's no longer taking new clients, but he continues to wrap up all client matters. Is it your notion that or intention with the retirement term and the submission forms to what he's actually doing? Retirement can mean different things, and I'm trying to make sure you two are in agreement as to what he's doing.
Certainly, and I appreciate that question. That was something that I've given a lot of thought to this week in preparing for arguments, Justice Biles. I would note the summary submission speaks to requirements of the probation plan and what the parties anticipate will be in the probation plan. The respondent then filed a probation plan on August 3rd of 2022 on the same date that the parties submitted the summary submission. This is a probation plan that Mr. Laing worked with the disciplinary administrator's office on prior to entering into it. And he notes in his probation plan in paragraph 3, subsection D, that the respondent agrees that by September 30th, 2022, or as soon as practicable, if he is unable to wrap his practice of law up by that date, he will not practice law for the remainder of the term of his probation. In visiting with the respondent further after seeing the affidavit that was filed on January 31st or Tuesday of this week, and seeing that paragraph 3 that he continues to wrap up client matters. In visiting with Mr. Laing, he has 5 clients left, I believe. One is a neighbor, one is a family member. He is assisting them in finishing up their divorces. He has closed his brick and mortar office completely. And it is my understanding from our conversation this morning, and he can speak to this more, that he will be done practicing completely by March of this year, which looking technically at the probation rule and our Supreme Court rule at Rule 227, it talks about what the plan is while on probation. And at this point, the respondent is not on probation yet. However, if you look at subsection F of this rule, it speaks to the need to, at least 14 days before oral argument, file an affidavit describing the respondent's compliance with each condition of the probation plan. And probation and attorney discipline cases is unique in that this is a self-directed plan that the respondent comes up with. This is a plan that the respondent shows good faith that he's going to be able to comply and will comply with the probation by showing he's complying with the probation prior to coming before the Supreme Court for oral arguments. And in this case, it does appear that the respondent is not necessarily complying with the terms of probation.
It a stretch of our rule on probation to make a condition of probation retirement. In other words, probation in it the notion of continued practice. Beyond probation and as a condition say, I'm not going to practice.
It is a term of probation that you do not see frequently in attorney discipline cases, especially. And again, I began my time up with you this morning quoting back to or citing back to subsection D of 227 when probation is appropriate, and looking at misconduct can be corrected by the probation, and placing the respondent on probation is in the best interest of the legal profession and the public. In this situation, in visiting with Mr. Laing leading up to the summary submission and the probation plan, he had indicated that he is ready to be done practicing, that he took responsibility for what he did in these matters. And by entering into a probation plan that includes an anticipation of retirement and not practicing law, this helps ensure that the respondent's practice is closed down properly, that he is able to move to the next chapter of his life after this. And I think it is a little bit different than if this was something that the disciplinary administrator is specifically asking the court to grant unilaterally, that we think that this attorney has practiced long enough and they need to retire. But because this is a summary submission, this is a way to comply with the guidance suggested in subsection D and accomplish those things and allow Mr. Laing as much autonomy and control and dignity in closing out his long career as an attorney in the state of Kansas.
What's your office's recommendation based on what you know now? And as you stand here, what are we supposed to do?
Because this is a summary submission agreement, and summary submissions are dealt with by the Supreme Court rule on that, we are bound by recommending what is in the summary submission agreement. This is something that we are aware of. As the court knows, summary submissions are a relatively new tool in the attorney discipline toolbox to use to allow a self-governing profession to allow the respondents to take responsibility and the parties to come to agreements together. But because there is no provision in the rule that speaks to what happens if there's a change in circumstances, or that something that is stated in the summary submission agreement does or doesn't occur, it is my position and my office's position that I am bound by the summary submission agreement that's before the court today, and am asking for that. I provided the information that I learned from Mr. Laing regarding where he's at with wrapping up his cases pursuant to paragraph 3 of the affidavit. So the court will know this and be aware of this new information that has occurred since August 3rd when we entered into this agreement. And I would note that the summary submission agreement notes in paragraph 65, it cites back to that rule 2223F, that the agreement is advisory only. The agreement will not prevent the court from making its own conclusions regarding rule violations or imposing discipline greater or less than the party's recommendation.
A little confused about the respondent's probation plan. That, do I understand? You said that you had worked with him on it. Is that the plan that you think is in place and is that you're asking us to put in place and is it acceptable? And part of my reason for that is I found when I was reviewing, as a preparation for argument, that paragraph 3 was confusing to me. It felt like there were provisions in there that were hard to reconcile, because it does talk about closing the office by September 30th, but then says that, of course, that would be with the caveat of ensuring clients' interests are not negatively affected. And then subparagraph under that, little II, says that if respondent's unable to close by September 30th, that the respondent agrees to the following and sets out that there will be lists provided to KLAP and ODA, et cetera. I'm not sure if that has happened from what you have said, But then later, under D, as you quoted, it goes back to agrees to be that if he can't wrap up, he will not practice law. So that little 2 and D seem conflicting to me. And so I was not real sure what the party's intent was here or what you were asking the court to do in terms of probation terms. But it also makes me believe that there is some leeway here with the respondent wrapping up his practice still as of today. So can you help me understand what the intent was and what you're asking us to do with by those provisions?
Certainly. And entering into this probation plan, when it was proposed and developed by Mr. Laing and signed on August 3rd of 2022, it was Mr. Laing's, I believe, and he can certainly speak to this if I get any of this wrong, Chief Justice, but I believe it was his desire and belief based on his assessment of his cases that he would be wrapped up by September 30th of 2022 with his practice and be done. But there may be a chance that there would be a few cases that would not be wrapped up by that point, and that he would work to diligently wrap those up as quickly as possible and keep the parties apprised. I would note that Mr. Laing did not provide monthly updates as set forth in subparagraph 2 of 3I. And I believe the justice asked that earlier. In visiting with Mr. Laing today, he did note that it is his belief today that he should be done with all of his cases by March, which depending on the court's reading of our rules that guide us, he will be at a place when he is actually on probation, should the court choose to grant him probation, that he will not be practicing law any longer. So I would agree with you that there is a little bit of wiggle room on here. There is not 100% compliance with even the wiggle room that was set forth in the proposed probation plan. And I can't speak as to why or why not that would be.
Clarify, if we would order a probation, it would be pursuant to this plan? Or are there additional? Just the bare bones, what's in the summary submission?
It would be in the respondent's probation plan that was submitted when we were preparing to enter into the summary submission agreement, because as Justice Stegall noted, this is a rather novel way of wrapping up one's career and resolving a disciplinary complaint. I wanted to make sure there was language in there for not only the president of the Board of Discipline that would be reviewing the summary submission plan, but whomever might pick up the summary submission and read it and see that we're putting him on probation, but it is a out of the ordinary probation. And as you can see by the rule, there's no requirement that a probation plan be submitted when a summary submission is entered into. The language I'll speak to before a formal hearing. And when you enter into a summary submission, a formal hearing doesn't happen. So there was a little bit of ambiguity based on our rules when the summary submission plan would be completed by Mr. Laing and submitted. And the proposed plan did end up being submitted the same day as the summary submission agreement was. but that wasn't necessarily an intentional working of all the parties together. That's the dates of where and how it happened.
Can I ask a question? You started off by saying that the ABA talks about probation and that misconduct can be corrected by the probation and it would be in the best interest of the public. And it seems like that everybody agrees on the misconduct and how to correct it. Normally what happens is you have during probation a supervisor that kind of monitors, you know, what's going on with cases. And so the misconduct can be corrected by probation because there's a supervisor meeting once a week, et cetera. And that's in the best interest of the public, you know, to protect the public. But here it seems like that the correction, the misconduct can be corrected by the respondent retiring. And what concerns me is, you know, if he had stopped practicing on September 30th, 2022, maybe that would be the case, but he's still practicing and really he doesn't have control over a docket or when a judge is going to say, you know what, we're going to continue this divorce case. So it may not be March and it may not be next September. And meanwhile, we have no monitoring and it actually could exceed the probation period. So can you speak to, I guess, the fact that the correction that you're talking about is him retiring? We can correct the misconduct by him retiring. And then, of course, he's not fully retired. He's not done practicing.
Absolutely, Justice Standridge. And that goes back to the conundrum that the position that the disciplinary administrator's office has been placed in now is when.
Well, I guess my question is, you know, you've asked for a 12-month suspension and then that suspension be stayed pending probation. Why shouldn't we just go ahead and do the 12 months suspension?
And that is certainly well within the court's purview to do that.
Doesn't seem like the misconduct being corrected by the probation plan that's been submitted. And it certainly doesn't seem like it's in the best interest of the public.
I would note, going back to your where you started with your question, Justice, is looking back to that paragraph, that subparagraph 2 in paragraph 3A. If the practice is not closed down by September 30th, 2022, respondent agrees to the following: provide KLAP and the disciplinary administrator with monthly updates due on the first day of the month, how many clients he has left, the names of these clients, and an update of the soonest possible date he plans to complete the case or hand the client's files off to another attorney.
And that's targeting the retirement. That's not targeting the misconduct. The misconduct was some bad decisions were made here.
Correct.
And what's to prevent some bad decisions from being made, even though I've let you know how many clients I have, I've given you an update on when I think the file is going to close, et cetera.
And I would agree with you based on the performance of the respondent leading up to this. I share those concerns to a certain extent because the probation plan anticipated that he would be done by now.
Basically be the same thing as a suspension.
Correct. And I would note, looking at our preamble, it talks about how the legal profession especially is a self-governing profession and the importance that we need to govern ourselves and show this respect for the rules, the law in our own actions. And the importance of that. And I do share your concern that this hasn't been met for the respondent. I would note, if you look at the summary submission, this respondent, when you're looking at the aggravating and mitigating factors, I would note that while this respondent has had 3 prior informal admonitions, he has never appeared before the court before on any sort of disciplinary matters. He has been practicing since 1983. I would note that he made a good faith effort for restitution in paying and writing off the outstanding balance of interest charged in the first complaint. And I would also note, and the respondent may speak to this today, in June of 2021, he suffered a stroke that resulted in health complications. And it's my understanding that in October, I believe, of 2022, the respondent had a heart procedure and stents placed in his heart that all signs seem to be pointing to he needs to slow down. He needs to stop practicing law, and by stopping practicing law, that protects the public. It allows Mr. Laing to retire from the profession that he has been in for almost 40 years. And it also allows him to take responsibility in knowing that if he doesn't comply at this point with whatever terms of probation the court ultimately imposes upon him, once he is actually on probation, the disciplinary administrator's office has procedures in place and has consequences in place for not following the terms of probation. So as far as making sure the public is protected, it is either protected by the filing of a probation violation, should he not comply with the terms of probation, or filing a new disciplinary case, should he violate our rules of professional conduct.
Questions?
Thank you.
First of all, I'd like to say I'm very embarrassed by this situation. Very sorry. Very humbling to me, and that I so sorry. Can't understand how embarrassing this is for me. Now, this has been a long process, and on several occasions I had conversations over the phone with Ms. Hart and told her exactly what was going on, that I had a couple of things that I was wrapping up, trying to wrap up sooner as opposed to later. And if any time she'd have told me, no, you can't do that, I would have dropped it. The only reason I kept these people had very little left to do. I knew if I dropped them, they have to go find an attorney, pay a retainer, all of this and all of that. And but once again, if she'd have told me, no, you can't handle these things, and I'll do that tomorrow. I just have no problem with that. I'll be glad to do that. I was just afraid I was going to make a situation worse for my clients, and none of these things that I still have going on are of much substance at all. They're just simple divorces that just need to get resolved. Now, I've got one neighbor boy. I told him when he first asked me to handle this, I told him I'm retiring and I'll get you as far as I can. That's where I am with him, and sure he'd understand if I told him that, you know, this is it, and I'll help you find an attorney or you find one on your own. But based on the language in that agreement, I felt that we could continue these things. I assure you, I didn't take any new things or wouldn't have continued if it had been very complicated at all.
Well, given that you continued, did you file them? I understood from Art that didn't file your monthly updates that you agreed. Effective, are you missing filing of any monthly?
I don't think so, Your Honor. First of all, the probation agreement had never been approved by this court. So I didn't think that it was a final document. And also, when I talked to Ms. Hart, you know, there was never any, you need to do this or you need to do that. And if there was, I would have done it. Ms. Hart correctly stated I had a stroke. I've had COVID twice. I've lost my long-term secretary. I've been struggling. And then in October, I had a heart attack and quadruple bypass surgery. I mean, it hadn't been fun the last year or so.
I want to be clear, that was October of 2022.
Yes, sir. So, I mean, I still am recovering from that and have chest pain every day. So I'm limited in what I can do. I don't want to practice law anymore. Really don't.
Mr. Laing, is it important to you, the way that the summary submission was 12-month suspension would be stayed and probation would be implemented? Is that important to you that it be probation instead of a suspension? Because you mentioned that you would drop all clients tomorrow and quit practicing law. So if we made an order that your law license was suspended, that would mean that you would drop all your clients tomorrow. Does it make a difference to you about whether we would impose a suspension versus a probation?
Honestly, it would make me happier if it was probation.
Because it kind of seems like that's what's going on here, because the probation terms are, I won't practice, which is really the practical effect of a suspension, but it's just under the probation heading. So I wondered if that was that was just really important to you.
I'd rather, be quite honest with you, have it called a probation than
Thank you for your honesty.
Does it make any sense? Probably not, but you know, I've done this for a long time. And I've done a lot of good for a lot of people. I mean, I just can't overemphasize how sorry I am. My whole life's been turned upside down in the last 2 years. I'm lucky to be alive here. And practice. I want to get all this stuff resolved. I don't want to come waste your time. I just want to move on with my life and get everything in boxes and get it resolved. And that's my goal. I don't want to cause anybody any problems. Like I said, you tell me I gotta stop doing this tomorrow. I'll tell my sister, I'll tell my neighbor, I'll tell the 2 or 3 other people, and that's fine. You know, it won't be the end of the world for them, you know, but I'll help them all I can.
How many clients do you have left now? And just an estimate of how much longer
I've got
representation would...
one in Missouri, and I'm not really even sure what that does, but he won't respond to me. I've been trying to tell him for a month or so that, hey, I'm not going to be your lawyer. We've got a trial set in March or early April, or maybe even be February. But finally, after he wouldn't respond to me, I filed a motion to withdraw like 3 weeks ago. Still haven't heard from him. So that's one. My sister and I can do, I've got everything done and filed except the decree. And if you want me to, I can drop her and she can go in and do it herself, you know.
On a general estimate of how many clients and how much is left?
I think I've got 4 Kansas clients left and then that one Missouri. I've got court dates. Got a court date for one of them. That's, I think, in March. That should resolve everything. It should. Like I said, it may not, but and then my sister and the neighbor. The neighbor's deal, the other attorneys, not real easy to get things settled with, so that may not get settled, but we do have a status conference in that in the next couple of weeks. So I could at least tell the judge, you know, here's what we're doing. I'm gonna retire, you know, find him a new attorney. I want to quit my practice. I could have done better. I mean, I could have told people I'm done, but it just seemed like it was going to be such a hassle for them. And the language in that agreement said, unless justice requires. And I've told Ms. Hart on several occasions, I'm still doing this, this, and this. And it never seemed to be a problem until today. Anyone else have any questions I could answer for you? Thank you so much.
Art, you reserve 3 minutes.
May it please the court. I would note in response to Mr. Laing's comments today that when you look at Rule 227, which is the probation rule, it notes under that subsection F that we spoke about earlier, the following provisions apply to a respondent who seeks to be placed on probation. When the times that Mr. Laing and I did speak on the telephone, the disciplinary administrator's office or myself is not in a position to order him to do or not do something at that point. It is his duty to know and to do what he is supposed to do. He was notified several times throughout the complaint of 227 specifically, of the rules of 227. And I believe that
So are you saying that, once a probation plan is submitted, does compliance begin immediately? Or is that something that is kind of ambiguous? This is the probation plan if the court decides to impose probation. And so at that point, I'll comply with the probation plan. Or is it something that, okay, now that I've developed a probation plan to show good faith, I'll start complying immediately?
And that's where probation, when you are an attorney on a disciplinary case, is a little bit different than in a criminal probation, where the conditions of probation are imposed by the court and then are being followed. In short, to answer your question, it appears that the way the rule is written, it falls on the respondent to come up with the probation plan, to follow the probation plan, and to
follow the probation plan when?
The date that keeps getting referred to in the rule is that 14 days. And you see that in that subsection F, that at least 14 days before the oral argument before the Supreme Court, the respondent must complete the following: file with the Supreme Court and the disciplinary administrator a copy of the affidavit describing the respondent's compliance with each condition of their probation and any relevant reports. Now, I do want to refer back to the preamble again, because I think that this preamble guides why our probation rule is what it is and why the responsibility falls largely on the respondent in developing and self-implementing a probation plan. If you look at section 10 of Rule 240, which is our preamble on page 321 of our rule book, it notes the legal profession is largely self-governing, although other professions have also been granted powers of self-government. The legal profession is unique in this respect because of the close relationship between the profession and the processes of government and law enforcement. This connection is manifested in the fact that ultimate authority over the legal profession is vested largely in the courts. And then you look at section 11 or comment 11 next, that says, to the extent that lawyers meet the obligations of the professional calling, the occasion for government regulation is obviated. Self-regulation also helps maintain the legal profession's independence from government domination. An independent legal profession is an important force in preserving government under law, for abuse of legal authority is more readily challenged by a profession whose members are not dependent on a government for the right to practice. And then 12 sums it up with the legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to assure each of its regulations are conceived in public interest. And it goes on and talks about that. But I would be so bold as to surmise that part of the reason why our probation rule for attorney discipline cases is written the way it is because we are a self-governing profession that has the utmost respect for the rule of law. And that's why the onus is placed so much more on the respondent to develop a probation plan and to have that probation plan carried out before the respondent appears before the court and asks the court to grant the probation plan. And I want to touch base on another question that you had asked, Justice Standridge. The disciplinary administrator's office has no teeth if a respondent submits a probation plan and we are pre-Supreme Court oral argument, that if the plan isn't being followed, I cannot file a motion to revoke his probation. I cannot unilaterally issue sanctions.
I think
That
Mr.
sort of
Laing is saying that he didn't know that the probation was effective right away. He thought he was submitting a probation plan and that it would go into effect when the court ordered it. So I think we have a basic misunderstanding or cross communication about, you know, was it in effect? And that was my question, but I'm good. Thank you.
Thank you very much.
Thank you to both of you for your arguments today. The court will take this matter under advisement.